Hi, everybody. This is Patrick Fife. I'm LIBOR's General Counsel. Welcome to the February 2025 LIBOR Legal Update. We're going through some very interesting times in the real estate industry. Lot going on. There's questions about commissions, agency relationships, fair housing. You read about lawsuits, settlements. Seems like there's constantly new laws, new trends, new risks, new laws, especially here in New York State, New York City. I know a lot of you will focus on what you read in the media, what you see in social media. Unfortunately, a lot of that avoids the real issues, the real facts, the real story. And another thing to consider is all of these new changes, much of it's beyond your control. So what do you do? Well, you have to control what you can control. You have to black out all the noise and figure out what it is you can control. So, what is that? Well, you can control having a system to stay on top of these changes, be aware of these changes, and you can have a system to get your information from the most reliable sources. And you're going to hear a lot from me today about having a system. And I think that's probably one of the most important takeaways that you can have. So I'm going to start talking about the system that you can use to stay on top of legal changes. Taking this course, which is required by New York State once every 2 years, is really not enough of a method or a system to stay on top of changes to the law. This course changes regularly. If you took a course like this 2 years ago, it would be drastically different than what you're going to learn here today. So the system that I would recommend you using is sign up for LIBOR's emails. Get our weekly email. We offer free legal tips. Basically, everything that's covered in this presentation has been covered in our legal tips over the last couple of months. Make sure that you visit LIBOR's website. You stay on top of different events, different webinars that we hold where we provide you with the latest information concerning changes in the law and new developments. And sign up for this class, really any legal update class, but certainly this free legal update class that's offered once a month here at LIBOR. I also encourage all of you to take a look at our website, lirealtor.com. Look at it once a week. When you get that weekly email from LIBOR every Thursday with the legal tip, click through, look at the past legal tips, look at the legal section of our website. In addition to access to the legal tips, we have all of our forms on the documents on demand. We have information about how to use those forms, what those forms can be used for, instructions on them. You have access to our dispute resolution center. So if you have an issue with another realtor, whether it's an ethics complaint, whether it's an arbitration against another broker, or you simply need somebody to facilitate communication with another realtor, we have free services for that. Our ombudsman service gives you an opportunity to have a neutral third party communicate with another realtor to resolve an issue that you might be having before it becomes a big issue, a legal dispute, a lawsuit. We also have a lot of educational materials for both you and for your clients. Different handouts on particular subjects that can make it easier for you to explain different aspects of the home selling and home buying process. We also recently launched a new legal support center. We provide our members exclusive access to a qualified attorney who can provide you with general information on real estate matters. This attorney is not acting as your attorney and cannot provide specific legal advice, but can certainly provide you with general information concerning real estate matters. So to access the Legal Support Center, it's available Monday through Friday during normal business hours. The number is 631-661-4800 and it's extension 335. So now I'm going to move on to a discussion about some fair housing best practices. Not a whole lot in terms of new laws with respect to fair housing, but there are some points of emphasis that I think everybody should be aware of when it comes to fair housing. Some particular areas of undercover testing, some particular problem areas that the industry still seems to be struggling with. So I'm going to go over some best practices to help you avoid any fair housing issues. So I like to point back to really two main concepts when it comes to fair housing. They're basic, and the first one is treat everyone equally. Very easy to say that, right? But how do you do that? The most important way to treat everyone equally is have a system. You need to have a system in place where every customer that comes in is treated the same way. That you are giving every customer the same document, asking for the same document and information from every prospective buyer, every prospective tenant. If you have a system in place, that will ensure that you treat everyone equally. So we're going to focus a lot on different things that you can incorporate into a system. The second is always make sure that you and your sellers, your owners, are focused on financial criteria. That's the only factor that's relevant as to whether someone has the ability to pay for a property. So a couple of other just best practices that I encourage everyone to follow. Know the laws, explain the laws too. I think it's very important. We'll talk a little bit about the Fair Housing and Anti-Discrimination Disclosure Form, which is a required form that you have to provide to all parties at first substantive contact. But it's more than just providing it. Be able to explain the form. Use it as a roadmap, an introduction to the fair housing discussion, so that you and your sellers, you and your buyers, prospective tenants, landlords, you're all on the same page about fair housing. Second thing is never answer a question if you believe it's going to violate the fair housing laws. Just simply say that's not a question I can answer. That's not relevant to the services that I provide. So if you're asked who lives in this building, who lives in this neighborhood, what are the people in the neighborhood like? That's not relevant to what you do, and it's not something that you can provide guidance on. Third, have a system. Use checklists, use forms, use templates. It's extraordinarily important to have a system because that ensures you are treating every person that comes before you the same way. Have good record keeping, document everything. Telephone discussions aren't documented. Follow up if you have an important discussion on any particular topic, fair housing, beyond fair housing, but fair housing in particular. Document it in writing with a follow-up email, a follow-up text message at the very least, and maintain those records as well. Obtain objective information from the consumer. Find out what the consumer is looking for. Let the consumer establish the geographical boundaries and limits. You should never be steering the consumer to a neighborhood. The consumer is the one that decides what neighborhood. You can provide them information on homes, but it's up to them to decide the neighborhood. Your focus should be on the property, the structure, not the neighborhood. So the New York State Housing and Anti-Discrimination Disclosure Form, I mentioned that before. One thing to point out, it is now available in multiple languages. New York State just recently released the form in several different languages. Previously, only the New York State Agency Disclosure Form had been available in multiple languages. But now the Fair Housing and Anti-Discrimination Disclosure Form is available in multiple languages. And remember, this is a form that you need to provide to all prospective residential or commercial buyers, tenants, sellers, landlords at first substantive contact. So anytime there's any meaningful discussion on the sale side about listing the property, on the buy side about price, terms, searching for particular properties, this is a form that you must provide. And I also highly recommend that you explain. It goes through what real estate licensees cannot do, and what would constitute a violation of the law. This form can be given in a variety of ways. It can be delivered by hard copy, email, text, fax, basically any which way. You have to maintain proof of that delivery for 3 years. Mentioned record keeping, very important when it comes to fair housing. If you provide it in hard copy and the consumer refuses to sign, you have to sign a declaration stating that you presented the disclosure form to the party and explaining the circumstances that the party refused to sign. Separate document, I think these two sometimes get confused because they came out at about the same time, is the New York State Fair Housing Notice, the Housing and Anti-Discrimination Notice. This is a document that should be displayed or needs to be displayed at all of your offices, also at all open houses. But also, it must be displayed, or a link to it must be on all websites created by real estate licensees. It has to be prominently and conspicuously displayed. So this includes any website where you will be advertising. So if you've created a Facebook or Instagram page, or any page on social media for that matter, or any page on the internet where you are advertising your properties, your real estate activities, you need to display a link to the fair housing notice. Social media is considered advertising. And that link should be prominent. So on your company website, on any website that you maintain for advertising, it should be easy for the consumer to find, which means above the fold, towards the top. It's not something that the consumer should struggle to find. This is an area that Department of State does periodic searches on. So it is important. It can result in a fine if you do not have it displayed. So very easy to fix, and something that you should check all of your websites for. So since we're on the subject of websites, what other information needs to be on a broker's website? We already mentioned the New York State Fair Housing Notice, but two other things. First is the broker standard operating procedures. Remember, all brokers in New York are required to have standard operating procedures that address three things concerning prospective buyers that come to their properties. Does the broker require identification? Does the broker require an exclusive buyer representation agreement? And does the broker require pre-approval for financing before they'll work with that buyer? Those broker standard operating procedures, a link to them must be on the broker's website. And the third thing, and this was a relatively new requirement that came out a few years ago. New York State released a reasonable accommodation and modification notice that's required to be provided to all prospective tenants that you're dealing with. It also must be on your website, and it's letting prospective tenants know that if they are disabled, that they have the right to request a reasonable modification or accommodation. So that's something else that must be on your website. More information on and links to the particular documents or templates for the documents are on our website, lirealtor.com. So go take a look there. And just like the fair housing notice, all three of these documents, there need to be clear and conspicuous. So it's not something that the consumer should struggle to find. What about associated licensee websites and any website that they're advertising on? So let's say you're a salesperson, an associate broker, you maintain your own website, which must be approved by your broker. We'll talk about that more later, but every website has to link back to the broker or brokerage website, provided the broker has one. So if you are, a salesperson, make sure you're linking back to your broker's website, that you provide a link to that website. Okay, so another topic I want to cover related to fair housing is avoiding lawful source of income discrimination. And why am I going to talk about this particular protected class? Well, it continues to be an area of emphasis by Department of State. It continues, I think, to be the most tested area of discrimination. It's a relatively easy area to test. Most frequently, it can just be done through a phone call. And I also think it's an area where, unfortunately, a lot of confusion still exists, and we're still seeing evidence of discrimination by landlords, apartment complexes, and reportedly some cases involving real estate licensees. So I think until that changes, you're going to see a continued emphasis on testing. So it's why it's very important for you to be aware of what your obligations are when it comes to lawful source of income. So lawful source of income is a protected class in New York State and at local levels as well, which means it's no different than any of the other protected classes, race, religion, gender, you name it. What does it mean? Well, a housing provider can ask a prospective tenant about income. They can say, what is your income? What is the source of your income? They can even require proof to document the applicant's stated income. That is not an issue. The issue is the prospective, the landlord has to accept all lawful sources of income equally. So a landlord can't say, I like this form of income better than another form. I can't say as a landlord, I like an applicant with a job better than an applicant who has income from another source, such as Social Security or public assistance. And that's because lawful source of income includes a variety of things. It's child support, alimony, foster care, Social Security, as I mentioned, any kind of public assistance. I think the biggest area that we've seen reports of discrimination come in the areas of vouchers, housing assistance, housing choice vouchers, Section 8, any kind of public program that provides assistance, payments, or credits. All of that is considered lawful source of income. So you as an owner, a broker, need to accept all of those forms of income equally. There's been major undercover testing on lawful source of income. A group called the Housing Rights Initiative has brought 4 lawsuits in the last 4 years and naming hundreds of property owners and brokers for denying access. And those lawsuits were based on undercover testing. The New York State Human Rights Commission has also done a significant amount of testing in the area of lawful source of income. They since 2017, and I don't this graphic is what is on the New York State Human Rights Commission website now. It's been there for a while, so this number may actually be higher today. But since 2017, so about over the last 8 years, they have assessed over $2.2 million in damages and penalties as a result of source of income discrimination. So that's why I say it continues to be a problem and it will continue to be a major area of undercover testing. And there have been repeated just in the last year news reports of source of income violations. Just this year, these are just 3 examples of many. And you'll see it can, in some instances, be blatant. Apartment complexes telling testers we don't participate in programs for Section 8. That is illegal to say that. Saying that we've reached our quota, we have limits on the number of voucher holders that we'll accept. All of that is illegal. So what is source of income discrimination? What can it look like? It can simply just be failure to respond to inquiries from voucher holders. It would be no different than a licensee or a landlord saying, I am not going to receive inquiries from a particular race, a particular religion, a particular gender. It is the same thing. Source of income discrimination can also look like just saying, I don't work with voucher holders. I don't work with landlords who take voucher holders. This is a big one. Let me find out if the owner takes vouchers and get back to you. An owner, if they're working with a broker, must accept vouchers, period. No question. This apartment doesn't take vouchers, or saying there's a wait list. Also, putting restrictions on those who have a voucher. If an agency has said that a tenant has the ability, or the voucher covers the rent, or the tenant has the ability to pay up to a certain rent with the voucher, that's the end of the inquiry. The landlord can't put additional burdens or roadblocks in the way of a tenant who has vouchers. So putting credit score, job requirements, income requirements on someone who has a voucher is discrimination, because that would prevent the person with the voucher from ever being able to get the apartment in the first place. The voucher covers the rent, or the agency has determined that the voucher holder has sufficient resources with the voucher to cover up to that rent. That's it. The applicant is qualified at that point. So how do you avoid lawful source of income discrimination? It gets back to that first point we had about having, having a system of treating everyone equally. So you're never going to turn away a prospect because they receive any kind of financial assistance. Regardless of someone's source of income, you're going to tell them about all the vacancies that meet their needs. Have a standard procedure for all prospective tenants that you use no matter what, regardless of source of income. So any prospective tenant comes in, you should have a standard list of questions, no matter their source of income. So you ask them, what areas are you looking in? How many bedrooms are you looking for? What is your price range? These are just examples, but you need to come up with a standard list of questions and proceed in that manner every single time. You're going to show a voucher holder the same apartments you would any other prospective tenant. So if a voucher holder says, I have a voucher for up to $2,500, you're going to show that voucher holder all apartments that were within their range, period. You will want to ask voucher holders for a copy of their voucher, the name of their caseworker, educate yourself to the details of the program. Again, asking a voucher holder for proof of their voucher, that is not discrimination. You're just asking them for their proof of income, just like not discrimination to ask somebody who is employed and saying that that's where their income comes from proof of their employment or proof of their wages. So very easy, just have a system in place. So now I'm going to move on to some new laws that you need to be aware of. A couple of these are already in effect. Some are going into effect. And we're going to cover four laws at this point. So the four laws that we're going to cover, the first is the New York City Fair Chance Housing Act. This went into effect January 1st. So it is in effect and it applies only in New York City. It requires all licensees, all housing owners, property managers to adjust their criminal background check procedures if they have them. If a landlord is going to, or a broker on behalf of a landlord is going to engage in a criminal background search for a prospective tenant, they must provide New York City's Fair Chance Housing Notice. And information on all of this, more detailed information, is available on our website. Go to lirealtor.com. We've done a legal tip on this. We have links to all of the information that New York City's put out on this, including the Fair Chance Housing Notice. So please take a look there. Another big change is that a criminal background check can only be done after the applicant's been approved and provided with a lease. So the criminal background check can't be done as a screening process. It can only be done once the prospective applicant has already been selected, approved, and provided a copy of a lease. So much later in the process is the only time where a criminal background check is permitted. The scope of the search is limited to reviewable criminal history, which it is generally includes or includes only registered sex offenses, convictions and arrests for misdemeanors that are less than 3 years old, and convictions or pending arrest for felonies that are less than 5 years old. There are limits now on what you could search. So if you're using any background search companies, you need to make sure that they're aware of this law, that their searches are limited to what is considered reviewable criminal history. And then once the search is done, there's a whole fair chance housing process that much must be followed. The applicant has to be given a copy of the search, the opportunity to respond to it, and then the landlord has to engage in an individualized assessment to consider the nature of the conviction, the time passed, and other mitigating factors. Again, please take a look at our website for more information on this. If you are involved in rentals in New York City, and if you are involved in assisting or performing criminal background searches for landlords. Another area related to rentals, and this is a statewide law. It goes into effect in April, and it has to do with short-term rental laws. New York State has expanded the definition of short-term rentals, and it includes basically any dwelling unit, room, or space within a dwelling made available for rent by guests for less than 30 days. Hosts of short-term rentals and booking services, which can include a real estate licensee. If you are listing a property for short-term rental on the internet, you may be considered a booking service under the law. In that case, the short-term rental or any short-term rental must be registered with a local registration system at the county level. Taxes must be collected now by booking services. So you'll see short-term rentals are now becoming highly regulated at the state level. If you are involved in short-term rentals, you should speak with your broker. Brokers, you should speak with your attorneys about what you need to do to make sure that you are in compliance with this law. I will also tell you that violating a short-term rental law can be grounds for significant discipline by DOS. There have been cases in the past where at the local level, brokers were dealing with short-term rentals that were not registered pursuant to a local law. So this is now a statewide law. Previously, there have been municipalities at the local level who regulated short-term rentals and required registration. And DOS has found that violating those laws can be grounds for discipline. So I don't see why they wouldn't find a violation of a state law to now be disciplined. So if you're involved in short-term rentals, you need to make sure that they're registered properly, that taxes are being collected properly, and in particular, if you're listing it, you may fall within that definition of booking services. So please make sure that you consult with your broker and attorney if you're involved in short-term rentals moving forward. Another area that I want to let everybody know about is the beneficial owner information filing deadline. If you're a broker, if you're a real estate firm, this is probably going to apply to you. The Federal Corporate Transparency Act requires that basically any corporation, limited liability company, limited partnership, closely held entity file what's called a beneficial ownership information report with the Financial Crimes Enforcement Network. Very easy to file. Our website, we have an article on this, how you go about, a link to the filing. And basically, all the report requires is that you provide information about the individuals who own or control 25% or more of the business. Their name, their date of birth, their residential address, and a copy of their government-issued ID. The deadline for doing this is March 21st of 2025. The deadlines move back and forth. There's been litigation over this in the federal courts. But as of now, as of February of 2025, the deadline is now March 21st, 2025. But another law that you should just stay aware of and have on the top of your mind. The last new law that I want to talk about, and this one has not gone into effect yet or taken effect yet. It has been passed. It just has not gone into full effect yet, is New York City's FAIR Act, not to be confused with the Fair Chance. This is FAIR, F-A-R-E, not F-A-I-R. And this law, it's in New York City. If it goes into effect, and it's scheduled to go into effect June 11th, it would prohibit landlords from passing the fees of their brokers on to prospective tenants. So it will prohibit tenants from paying fees to the landlord's broker or covering the landlord's broker fee. It is being challenged in court right now. If it does take effect, landlords in residential transactions will no longer be able to charge brokerage fees to their tenants. So if you are representing a broker in New York City and this goes into effect, you're going to need to make sure that you're not advertising that the tenant is responsible for your compensation. And you're also going to want to make sure your compensation or listing agreement with that landlord doesn't provide that the tenant will pay for your fees. So another law that you need to keep an eye on, and stay tuned for more information. Now I'm going to just cover some best practices for advertising. And the reason I'm doing this, these are not new laws, but they are a point of emphasis by Department of State. The Department of State has been looking at improper licensing. They will issue fines. They have issued fines. Every month, we see consent orders or decisions that come out where real estate licensees have violated the advertising laws, and it can be significant. You could be looking at thousands of dollars of fines. So it's very important for you to follow the Department of State regulations concerning advertising. And the good thing, I think, from the Department of State's perspective, they've done you a favor. They provide what's called a real estate advertising checklist. It's one of the handouts that you will receive with this class. It's available on the Department of State's website. It's available on our website. But it goes through all of the steps and all of the things that you need to have in your advertising. So if you just look at that checklist and compare it on a regular basis, maybe twice a year, with all of your advertising, it's a very good way to stay in compliance. So I'm going to give you an example of some what could be thousands of dollars of fines right here. So what's wrong with this business card? I will give you the disclaimer. I am not a real estate licensee, so this is just a hypothetical card I've used myself. But Pat Fife, corporate vice president and licensed associate broker for Your Home Dream Team. I've included my license number, so that seems good, right? I've included my phone number and an email address. Well, I can count at least 5 violations of the real estate advertising regulations on this card. There's also a trademark violation here. So let's explain why. What are the issues here? First, I didn't identify my proper license type. I called myself, right? I called myself a licensed associate broker. That is not a proper title. It's associate real estate broker. Look at your license. You have to make sure that what's on your business card, your email signature, all your advertising matches what's on your real estate license. I can't just simply use a incorrect license type. So I'm not a sales agent, a real estate agent, a broker, an associate broker. It's real estate broker, associate real estate broker, real estate salesperson, period. Can't use a corporate title unless I'm the broker of record. So I used a corporate title in that example. Yet I was only an associate real estate broker. I am not entitled to use a corporate title. I didn't include my brokerage's name. I included my team name, but a team is not the brokerage. Teams must advertise the broker's name. I also didn't include my broker's address or office phone. I just included my cell phone in that example. So that was another problem. I also used a nickname. My name is Patrick Fife. That's my license name, at least for my law license. So I can't just use Pat Fife. You are permitted to use a nickname, but it has to be appear with your full name. So I could do Patrick Pat Fife, but I can't advertise myself as Pat Fife. Look at what's on your license, match it up, name and title. You do not need your license number. I know a lot of folks put that on there, and that's okay. There's nothing wrong with that, but it's not a requirement. And putting it there won't absolve you if you fail to include all of the other information. I mentioned the trademark violation. My example also had a trademark violation in terms of saying I was Suffolk County's realtor. The realtor mark has to be used properly. Um, it's really only used to identify yourself as a realtor member, a member of the National Association of Realtors. So it shouldn't be used and cannot be used with geographical modifiers like at Suffolk Realtors, at Queens Realtor. It should be used only next to your name. It's identifying yourself as a member, period. It's a mark that you share with all of the other 1.5 million realtors in this country. It is not yours to attach or say that you are New York's realtor or Suffolk County's realtor. You can't use it in that manner. It is a violation of the law to do so. Also, make sure that it's not a substitute for your license type. I've seen a lot of advertisements where people say, I'm a licensed realtor. Well, there's no really, we realtors associations don't provide your license. New York State provides your license. So saying you're a licensed realtor is not a substitute or it does not satisfy the state advertising regulations. You have to use your proper license type. You certainly can, and we want you to identify yourself as a realtor in addition, because it puts you at a higher level, a higher standard. Um, but you also have to identify your proper license type. Just remember advertising on social media, it's the same thing. So if you are putting your listings and talking about your real estate activity on social media, you have to make sure that you're following the advertising regulations. So that would include a link to your broker's website, your broker's name, your proper fully licensed name, your license type, all of the things that we just mentioned before. It's no different. And I will also say, I think it makes you look more professional. Looking on social media and those that don't follow the regulations, I think it puts them in a questionable category with consumers because a consumer might be confused. Is this person scamming me? Is this person really a real estate broker? I don't see a name of a broker. Who am I dealing with here? You want to give the public the assurance that they're dealing with a legitimate real estate licensee. So it's really to your benefit on social media to make sure that you are following the regulations. I think you look more professional when you include your license name, your broker's office phone number or address, a link to your broker's website, a link to all the required notices. So not only is it required, it helps you get more business. So go make sure after this class, you look at the advertising checklist. And if you're advertising on social media, incorporate the requirements on that checklist to your social media accounts. Next topic that we are going to cover is the NAR settlement that was approved in November of 2024. And we're going to cover some best practices to avoid antitrust liability. Also, some frequently asked questions that have come up in the last month to our legal support center. So there were two key terms to the settlement. I'm sure you're all aware of them now, but they are: one, offers of compensation are prohibited on the MLS. And the second is MLS participants working with buyers have to enter into written buyer agreements with their buyer before touring a home. So the most questions that we've had to the Legal Support Center have focused on that second requirement, that relating to buyer representation agreements. So we're going to go through a couple of those now. The first that comes up and it seems to come up frequently is, well, what do the rules say? The MLS rules that have gone into effect, what do they say that buyer representation agreements need to contain? First is if you're going to receive compensation, the agreement has to state the amount or rate of compensation and how that amount will be determined. Second, it has to indicate that that rate or amount is objectively ascertainable. It can't be open-ended. So you can't use any ranges, sliding scales. You can't say that compensation is going to be whatever a seller agreed to offer the buyer. It can't be between X and Y. No ranges, no sliding scales, must be objectively ascertainable. It can be any amount, any rate, hourly, flat fee. There's no limit on what you can do with a buyer. You just can't have ranges or sliding scales. Uh, Third, must provide that you cannot receive compensation for brokerage services from any source that exceeds the amount or rate agreed to in the buyer agreement. We'll cover that more later, but basically, if you have an agreement with your buyer that says, I'm going to be paid X, this is my fee for the services I'm providing, and a seller or a listing broker are offering Y, and Y happens to be greater than X, you can't collect that difference. You can only collect X. The buyer is setting the rate or amount that they've agreed to pay to pay their buyer representative, and that's what you can collect, period. Another question that comes up a lot is do I need to have a buyer who shows up at an open house sign a buyer representation agreement? The answer is no. When you are at an open house as the listing agent, you are representing the seller. You're not working for the buyer. You're not working with the buyer. You may be providing a buyer information about the property, which you have an obligation to do, but you're not representing that party. You're there to represent the seller. So you can absolutely show a prospective unrepresented buyer your listing without a buyer representation agreement, provided you're not also representing the buyer, which we're going to talk about in a second. But you at an open house are representing the listing, the seller only. Well, what about a dual agency situation? So, what if the same broker is working for both the seller and the buyer? In that instance, yes, you would need separate agreements with each. If you're working as a dual agent or in a dual designated situation, you would need written agreements with each. But remember, in order to have that scenario arise, there's other things that must and absolutely must happen first. You must have the seller and buyer have already signed agency disclosures giving advanced informed consent to that dual agency relationship. The advanced informed consent, it has to be fully explained in writing. NYSAR recently updated the advanced informed consent to dual agency and dual agency with designated sales agents disclosure to cover the scenario where a listing agent is contacted by an unrepresented buyer who wants representation, but you cannot, in that open house situation, represent an unrepresented buyer unless you have that previous advanced informed consent from the seller. And that advanced informed consent needs to be in writing, and you have to explain the what dual agency means, what the seller is giving up by consenting to it, explaining that the seller is giving up their duty to undivided loyalty. All of that must be explained to a seller before you can get agree with a buyer to also represent them in any kind of dual agency scenario. I encourage all of you to take a agency course. Go on our website. Please review all of the recent articles we've put out about agency. It's very important that you understand agency. And I think one thing the settlement has kind of renewed emphasis on is agency and the importance of agency disclosure, and also the importance of making sure if you are engaging in dual agency that you have the proper and required consent to do so. Speaking of agency, what about a broker's agent? Question comes up, if I'm a broker's agent, do I need a buyer representation agreement? And can I show buyers homes without a buyer representation agreement? Well, you can't be a broker's agent unless you have the advanced approval of the listing broker. A broker's agent is someone who is working as an agent of the listing broker. So you can't basically approach a prospective buyer and say you're a broker's agent and I can take you out without an agreement unless you already have an agreement with the listing broker to act in that manner. Um, you must make sure that the seller and listing broker are authorizing broker agency before you can act in that capacity. You cannot, as a broker, unilaterally decide to act as a broker's agent. You must have the approval and consent of that listing broker. All right, what happens if a seller's not offering or advertising any kind of offer of compensation? They won't tell you anything. You see a listing, you contact the listing broker, and they say, my seller's offering nothing, or my seller hasn't authorized me to say anything about compensation. What do you do? Um, doesn't matter. There's really nothing different. You're going to show the property if it fits your buyer's criteria. It doesn't matter if the seller's offering compensation or not. If you represent the buyer, you're going to show them every property that fits their criteria and that they're qualified for. And if your buyer's interested in the property, you're going to get their permission to include your compensation as part of the offer and negotiate. Very simple. Compensation is always negotiable. Just because a seller isn't indicating that they would pay compensation to a buyer's agent or that they've said that they wouldn't, doesn't mean that they won't. At the end of the day, every seller is motivated to sell their property for the best possible price. And if that price includes, at the end of the day, the best deal includes compensating a buyer's agent, that's what a seller is going to likely do. So you should look to work in the buyer's best interest, show them every property, and then include whatever a compensation that the buyers agreed to pay you as part of the offer and negotiate from there. What about timeframes? Is there a time frame a written buyer agreement needs to cover? Can you have a written buyer agreement for just one home? No time frame. Open. You can have it for one day, 1 week, 1 month, and it can be for just one home or multiple homes. It can be structured any way that suits the needs of the buyer broker and their client. The settlement doesn't dictate the scope, the duration, and it also doesn't dictate whether you use an exclusive or a non-exclusive agreement. So what do you use? Which one? Are you forced to use a particular one? No. You can use either. It depends on whatever situation the broker is in and what they want to use. But remember, the exclusive buyer agreement, that's going to commit a buyer to working with only one buyer's agent for a set period of time. The buyer it's effectively a marriage. They can't bypass that agent during the period of the agreement to work with anyone else. The non-exclusive agreement is allows that buyer to work with more than one buyer's agent at a time. There's no long-term commitment at that point. And the buyer's agent's only going to be paid if under LIBOR's non-exclusive buyer agreement, if they're the procuring cause of that transaction. So this may be a good choice if you're starting out a new relationship with a buyer. You want to see if you and the buyer are a good fit. Remember, each broker decides what type of agreement they want to use in a particular situation. One thing to note for brokers, if you are a broker who has decided that you are going to only work with buyers under an exclusive buyer representation agreement, you must update your standard operating procedures. I know there may be brokers out there who've made that decision, and if they have, it just needs to be indicated in those required standard operating procedures. If you're a broker who, depending on the circumstance, uses exclusive or non-exclusive, does not have to be in your standard operating procedures, but nothing to prevent you from having procedures. And I would encourage you Have a plan, have a procedure that makes sure everybody in your office is aware of and that they are following. Next question. Can a buyer representation agreement be amended? Yes, it can. But be careful. It should only be amended under certain circumstances. Um, if, let's say, there's a business reason for it, has the nature or the scope of the services you're providing changed? If so, and the buyer agrees, it's rational or reasonable to seek an amendment. But you should never be amending an agreement simply to match the compensation that a listing broker or seller are offering, just so you can receive more than you agreed to with your buyer. And remember, the buyer has to agree to any proposed amendment. So you should be explaining if there is a reason you feel the agreement should be amended, you need to explain to the buyer why you think the agreement should be amended or needs to be amended, and make sure they understand what they're being asked to do and what they're agreeing to potentially uh, to give up or to gain. Make sure any amendment is explained and understood by the buyer. Couple more questions. Does the buyer's agent need to provide their written agreement to the listing broker? No. The listing broker asks you as a buyer's agent to provide your written buyer agreement. You should not be providing it. It's a confidential document between you and your buyer. Just like you have no right as a buyer's agent to see a copy of the exclusive right to sell agreement or listing agreement between the seller and the listing broker. The listing broker doesn't need to confirm what the buyer and buyer agent have agreed to regarding compensation. That's between them. Um, Simply, the listing broker and seller should independently make their decision about what compensation offers they want to make based on what's best for the seller. It's irrelevant from a seller's perspective what the buyer and buyer agent have agreed to. The seller should be concerned on what's the best deal for me, not what the buyer agreed to with their broker. So, no obligation for the buyer's agent or the buyer to disclose or provide a copy of their agreement to the seller or listing broker. Please make sure you're avoiding any of these workarounds. They're not permitted under the settlement. One, accepting seller paid bonuses to the extent that any bonus would go above what the compensation that a buyer and buyer's agent agreed to. That is not permitted. Um, Supplementing touring or showing agreements with another buyer representation agreement. So effectively saying, my services are free, showing the property and then showing the property again under a different amount. Again, including ranges or compensation in a buyer representation agreement. And we've kind of covered this one already, but tailoring that buyer representation agreement to what the seller is offering, or leaving it open-ended or leaving it blank to be filled in only after you find out what a seller may be offering. The amount or rate of compensation the buyer's agent and the buyer are agreeing to needs to be set up front before touring the property. That's what the settlement requires. That's the spirit of the settlement. Don't try to work around it. All right, next we're going to cover just real estate broker duty of supervision. And I'm just going to do a very general overview here. If you are a broker, you need to make sure that you're engaged in consistent, regular, frequent oversight. So the law says that the duty of supervision is regular, frequent, and consistent personal guidance, instruction, and oversight. That's what's required by the law. Even if your associated licensees are independent contractors, you still have a duty of supervision to make sure that they are complying with the law. Office managers, you have that same duty. So if you are an office manager, you have the same duty of supervision as the real estate broker. And why is that important? Because Department of State can charge the principal broker and office manager for a failure to supervise if their associated licensee commits some kind of violation. So brokers need to be able to point back in that instance to say, wait, my licensee may have violated the law, but I have supervised them. Here's my proof of supervision. Here's what I've done. And we're going to talk about what that consists of in a second. Also, make sure that as a broker, you're aware that you have oversight responsibility for your associated licensees advertising, and that includes websites as well. So any website that's created by a salesperson, associate broker, needs the broker's approval, and the broker is ultimately responsible for that advertising. You can't simply plead ignorance. Brokers are also responsible for team activity. Teams are not a legal entity. Teams are recognized in New York only for advertising purposes. They can't enter into agreements. They can't enter into independent contractor agreements. Um, if a broker has a team working for them, the broker is responsible for the team. If a team or team member did it, so did the broker. So please make sure that if you have teams as a broker, you are exercising oversight over them just like they were any other salesperson. So, what are your best practices when it comes to supervision? I know that sounded like a lot. Go back to what I said in the beginning. You need a system. You should have a system to communicate regularly with your licensees. Make sure they're aware of all of your policies. You should have policies. You need your standard operating procedures. You should have other office policies when it comes to certain instances. Make sure that everyone in your office is provided with those policies, aware of them. Make sure you have a system of regularly communicating changes in the law, changes in the rules, new developments. Make sure, look, forward all LIBOR's weekly legal tips. Do a summary. We've provided on our website a whole broker portal that gives you a monthly resource deck to share with your licensees. Have regular meetings where you review that information so you can point back in the event you're brought in for a failure to supervise. Here's all my evidence of supervision. Here's the regular training programs that I offer. Here's the regular communication that I offered. Here's the schedule of me making myself readily available to answer questions. Have all of that in place. Lastly, you need to have a system to track compliance. Do you do periodic check-ins to make sure that your licensees are complying with their legal obligations? And have you responded to and addressed issues of serious concern? This is the other part of supervision. It's one thing to have a system in place, but if somebody does commit a violation that you uncover, what have you done? Have you disciplined them? Have you educated them? You need to be able to demonstrate that to Department of State to demonstrate that you're engaged in that regular, frequent supervision. Last topic for today is a watch out for vacant land sale scams. This has been a prevalent issue nationally, but it seems to continue to grow here at a local level. All across Long Island, I know significant issues in eastern Suffolk County. Scammers are taking advantage of our low inventory. They're hoping you're going to rush into a listing, and they're looking at vacant land because it's almost logical to think, well, no one's living there. There's no structure, right? So they're contacting you by text, by email, sometimes by phone, but they're getting public information about the owners. They're impersonating those owners. They're creating legitimate looking fake IDs and trying to bait you into taking the listing in the hope that ultimately there'll be some transaction and money will go to them. Some of these transactions have closed. Even the ones that don't, though, you risk damage to your reputation. If a buyer engages an attorney and does due diligence into a deal that ultimately they find out was illegitimate, they're going to be pretty annoyed at the listing broker. If a seller finds out that you've listed a property, or the actual owner finds out you fraudulently listed a property for sale, they're going to be pretty angry. And very likely they may say things about you. So certainly I think you want to make sure you protect your reputation, you protect yourself financially, and you don't take one of these scam listings. So the red flags, look, it's going to be somebody who's looking to sell quickly. They're going to claim they're out of state, out of country. They may try to say they want to sell for a low price. What can you do? This is the most important thing. Have a process in place for any vacant land deal. Before taking any listing for vacant land, and I would almost say this for any listing, you want to have a process, a system that says you require an in-person or Zoom meeting. That is the best way to protect yourself from this scam. You also want to ask for multiple forms of identification. If it is a vacant property, you should independently search the internet, try to verify the owner's phone number and email, and contact the person that is listed at the owner at that contact information. If there is a scam you believe you're involved in, contact law enforcement, remove the MLS listing and all advertisements, and that would be the best practice to follow. Lastly, just be vigilant for other scams. Make sure you enhance your cybersecurity. Our industry is a target for scammers because we deal with significant transactions that involve significant amounts of money. Even if you're not handling the money, you're an entry point into the transaction. So please look at your cybersecurity, dual factor authentication. You don't want to be the entry point for a wire fraud or a scam. My best advice, slow down. That's the best way. If things are moving too fast, there may be something wrong. Slow down, in especially the beginning of a transaction. Do your due diligence. Make sure you're dealing with a legitimate party. Thank you for attending today's class, and I look forward to seeing all of you at a future legal update. Thanks.